Welcome to another edition of Eusebius on TimesLIVE. Now, the previous entry of this podcast for TimesLIVE, you would have heard me explaining the legal challenge that public enterprises and Eskom are facing. A letter of many demands had been sent to them by a number of clients that have approached various law firms. Essentially, these clients want the blackouts to discontinue immediately, but the list of demands are quite wide. And while they have to deal with energy insecurity, the big question is, what are the prospects of the state responding to the demands effectively by Friday? And if they don't, what is the legal strategy beyond that? Now, one of the lawyers involved is Siphile Buthelezi from Buthelezi Vilakazi Inc. And he has agreed to join me to get to the bottom of the legal logic behind this particular matter. I think you and I as South Africans understand experientially the impact of blackouts. Politically, this is significant, but fundamentally, this is legal action. So I wanted to engage one of the lawyers involved on the legal elements of it.
You're listening to Eusebius on TimesLIVE. That's this latest podcast on TimesLIVE. And it's me, Eusebius McKaiser, exploring the major issues of the week. That means you're going to hear a lot of law, politics, and ethics, how they intersect, and how important these stories are in the life of all South Africans.
When people saw
their children must know these are sellouts.
They put saliva on the paper.
Mr. Julius Malema whispered and said, sing it, sing it.
And then they shared that zone.
No, I'm not going to apologize to you guys.
Can I have my iPad, please? So they stole it.
Siphile, thanks so much for joining me on TimesLIVE.
Thank you very much, Eusebius, for inviting me.
Let me ask a general question before pressure testing the legal strength of your argument. What is the legal case?
Really, for now, the legal case is based on the constitutional obligation of the state to ensure power supply, power generation, or transmission and delivery thereof. So that's where it emanates. I think in the past, we have not really looked at that aspect of the load shedding that we are facing as a country, and how then the failure by the state to ensure that it adheres to that obligation has then started, to breach some of the constitutional rights that citizens are supposed to enjoy.
Let's drill down into the legal parts of this case. I'm going to leave for the second part of the discussion which rights are implicated when electricity is not securely provided. But I want to start with the first thing you said. And I want to ask the question in this way. Do I have a right to a secure supply of electricity?
Yes, you do.
What source of law justifies that claim?
Firstly, it emanates from the state saying that it should be the sole provider of electricity. So once the state takes that responsibility, it then becomes an obligation, constitutional obligation, not just constitutional, but also national legislation. It's only now where we have seen recently where the state is starting to grant licenses to independent suppliers. But ordinarily, it was the duty of Eskom, who is the supplier. So it means that once the state takes responsibility to be the sole provider for in this case, of energy, then we look to the state for such energy. So legislation, constitution currently put that obligation on the state to ensure that there is power supply, there's generation, and there's transmission.
I looked at the Constitution, the Bill of Rights in particular, in preparation for this interview. I can't find anything like that. The Section 27 socioeconomic rights refer to more obvious things that have been the basis of case law over the years, as you know, whether it be access to the progressive realization of water, healthcare, education, housing. Those are the classic ones that enabled organizations like the TAC or Equal Education, or in the Grootboom case, or the Subramani case, to then challenge whether or not government's policies are compliant with the Constitution. There's nothing like that references energy specifically. You're making it up.
No, we're not making it up. Eusebius, as I indicated, there's national legislation. As you are aware that it's only recent where now government is looking at giving the rights to mining companies to generate electricity, because the legislation that currently, the law currently only empowers Eskom to be the producer. And now we have seen, in fact, I think last year, to be specific, where now there's independent power generators who have been granted licenses to generate. Remember, it's the state that can grant that license. So it means that currently you cannot produce electricity on your own unless you have that license. And those licenses previously were not being granted to individuals. Otherwise, then, if we look at it, especially the mining houses who do have capacity to produce their own electricity, they would have been doing it all along. So that's the reality that we've been facing in this country.
I completely understand that reality from a practical point of view. In other words, a practical import of the existing regulatory regime is precisely what you've laid out in the last 5 minutes. But there's a massive difference between saying the executive branch of government has got the constitutional space to create policy, including a licensing regime, and saying those of us who are hoping to get licenses now, for example, to become IPPs, that we have a right to a license. There's an important legal ambiguity both in your letter of demand and in your answers to me. And that ambiguity is between, does government have policies that are sensible, which is one question, and a separate question, which is the kind of question judges will ask you, that the average Joe doesn't care about, because they care about the first question, is the policy rational, and is it delivering electricity for my house right now? And so there you've got the court of public opinion on your side. But lawyers and jurists will ask you a devil's advocate question, which is to say, is there a legal obligation on government to not have stupid policy? And surely the answer is no, which is why we've got votes and elections, because if we don't like the policies, we get rid of them. So in a sense, you want to ask the courts to encroach on the exclusive governance domain that the executive has been granted constitutionally, and your chances must be slim to none. That's overreach.
I don't think so, because if you look at our letter, it basically talks about an obligation, and then how then the failure to supply has then started caused the breach to the constitutional rights that citizens should be enjoying. So really, at the end of the day, is that if the state currently has the sole mandate to generate electricity in this country, and its failure to do so then start, violating constitutional rights that you and I are supposed to be enjoying, then obviously then somebody has to take accountability, which unfortunately the state has not been coming forward with, especially when it comes to transparency, as it were, and keeping everyone on the same page in this particular issue.
A last issue I want to canvass for now. We can return to these issues in the weeks ahead. I hope, well, you don't have to agree with anything I say for that matter, but I think you probably would agree that it's not a slam dunk. It's at best interesting legal action, because in the cases that I alluded to earlier, that are classics in case law, where government policies, whether it is something as precise as you can't stop an HIV positive soldier from being active as an SANDF member, or whether it's something as general as access to nevirapine. There are many examples where we've had good test cases where policies have been put on trial legally because that's the point of constitutional supremacy. But I think, and I wonder what you think of this, Siphile, I think those cases that have succeeded had one thing in common that your letter of demand doesn't have, that there was a shorter causal link between the text in the Constitution and the relief that was being sought. Whereas the kinds of things that you are asking for, tell us about the content of your deal with Biden. Tell us that you will not, in fact, go ahead and enjoy the 18.6% tariff hike. I mean, it's all over the place. Some of it implicates rights that are indirectly breached as a result of the blackouts, like a lack of security, operations that don't happen at the hospital. But some of it is just the hurly-burly of what governments are elected to do, which is to take a mandate to run with it, and then we go back to the polls 5 years later. Did you not make a tactical mistake by asking for too much?
No, we haven't. Remember, Eusebius, this is a letter of demand. It's not yet court pleadings, as it were. Depending on the response that we will receive from government, then we'll then make a legal argument in our pleadings, as it were. As I said, that currently in all 9 provinces, my colleagues from different law firms are taking these statements, sitting down and really understanding how the various clients have been affected by load shedding. And then thereafter, then we'll put together a legal argument, in fact, showing the causal link that you are referring to right now, and why the state should be liable. For example, one of the demands is that some of the clients are requesting for compensation for the loss that they have suffered. So obviously there we need to put together a legal argument as to why the state should be liable if you have had to close your business, for example, due to load shedding. Why your state should be liable if your house has burnt down, in some cases, in case and when electricity comes back. So all of those things will be in our papers, and which we are going to lodge probably before next week Friday. That's the instruction that we have, and then we'll be able then to really touch and expand on some of the issues that you just raised.
Well, I look forward to seeing how it will unfold. I've looked at, in a cursory way, the public's response to this announcement, and it's clear you've got the public on your side: black, white, pink, orange, colored, whatever. People in different provinces, because from a popular point of view, it makes complete sense. In law, there's precedent. The whole point of constitutional supremacy is that even government policies can be tested for rationality, reasonableness against case law and different sources of law, not least the Constitution itself. But there's something about the particular elements of this case that I think will divide many of you and your peers. It'll be really interesting to see how it travels. Thanks so much for coming on.
Thank you very much, Eusebius, for talking to us, and will be available in the next week or so, again to expand or explain some of the arguments that we put forward in our pleadings.